Maraming salamat, daghang salamat. And that puts me in an even more awkward situation, more difficult and awkward situation, for various reasons. I have 5 points to make, but before I talk about specific questions of justice and what the notions of justice in the future and in the present and about the past might be, some background about myself so that I also put some context into where I'm coming from. I work for ICPJ. It's an international NGO based in New York. So I work from New York. But before I started working with ICPJ, I worked at the Philippine government. My last job in government was commissioner in the PCGG, going after the Marcos family. And without going into that long story, part of that job was to draft a law that would provide reparations for victims of the Marcos dictatorship. And it took a while. It took 10 years. I drafted the law before I left for New York in 2003. The law was passed last year. 2 years ago, 2013. So it took 10 years just to pass a law to acknowledge the victims of the dictatorship. Before I worked in the PCGG, I was actually in the Defense Department, in the Department of National Defense. I was Assistant Secretary in the Department of National Defense. Who was the president at that time? It was Joseph Estrada. I was perhaps in my second year as Assistant Secretary of Defense. Joseph Estrada was in the middle of a meeting with the Catholic bishops. I'm not sure if it was the CBCP or a group of bishops. They were having a meeting. Estrada was threatening to unleash his all-out war that week. The target was Camp Abu Bakar, among others. And part of my work was to ensure that the armed forces would follow civilian authority. It was among the many things I had to do. I was one of the few civilians in the Department of Defense. I was, in fact, the only non-military person who has ever held that position in the Department of National Defense. And I think even now. So Estrada was in the meeting. We were trying to verify from the armed forces whether they were standing down, waiting for that meeting to end. But while there was a meeting going on, we were told that Air Force planes, OV-10 bombers, which are not real bombers, these are trainer aircraft, were already dropping bombs on Camp Abu Bakar, right while Estrada was in a meeting with bishops. 3 days later, I was asked to go to Camp Abu Bakar. And so I went in an Air Force helicopter. That was the first time I ever went to Camp Abu Bakar. Went in with some of the soldiers that were asked to hold the camp right after that offensive. The first thing I saw was a huge crater. And it was explained to me why the crater was huge. OV-10 aircraft are not bombers. The only way they can drop bombs is to open a hole and literally drop the bomb. If they drop the bomb and the aircraft is low, they would also get hit by the explosion. So they would have to drop it from a very high altitude, which means you sacrifice accuracy for destruction. And so that's what they did. So I went inside the camp. First thing I saw was a crater. Inside the crater were two things that I still remember up to now. One thing was a wall clock, which showed you the time it was destroyed. And the other was a baby walker beside the wall clock. There were other things I saw. There were other things that I had to collect, interviews I had to do for my job, for the work I was doing. But it was among many reasons that I decided I would resign from government. I have not gone back to government since then. The reason I'm telling this story is that there are ways to end a conflict, and obviously that is one way to try to end a conflict, to destroy your enemy. And in the work I am doing now, transitional justice, which I will perhaps not have time to explain, transitional justice has also been brought up as another way to try to end a conflict. I am not going to say that it is always successful. I am not going to say that it is always clear and effective. But it is certainly not a way that is destructive. One of the countries most often mentioned when we talk about transitional justice is South Africa. I usually do not talk about our work in South Africa. We used to have an office there. I was there just a few months ago. But in this case, I think it's worth mentioning. In the middle of peace negotiations between Nelson Mandela, who one of our senators is apparently very familiar with, in the middle of negotiations between the ANC, led by Nelson Mandela, and the apartheid government, one of the points they agreed on was to amend their constitution. And you will see it now. At the end of the South African constitution, it does not have a number. It does not come with a section or a chapter or an article, because it came way after they drafted their constitution, the post-apartheid constitution. It's a small, they call it the post-amble, as opposed to a preamble. It's a small 3-paragraph statement about reconciliation and unity, and the most important part is acknowledgement. That they acknowledged what happened to the African community that had to live under apartheid. And when, one of the most important quotations I remember in the history of that negotiation was the decision of the ANC to stop fighting. The decision to stop fighting, they said, was because the price of victory would be too high. And not that there are exact parallels to what is going on now or what has been going on, as Congresswoman City has mentioned. But that, I think, is crucial when we try to respond to proposals to end the conflict through all-out war, through the use of military force. But I am here to talk about justice and to talk about how our notions of justice might be helpful in responding to those who, for now, want to end the peace process, or even in responding to the injustices that those who have suffered have not received in terms of justice. So the 5 points. First, perhaps the nature of the peace process. We often see it as a formal process. We talk about the peace panels. We see the members of the government panel. We see the members of the MILF panel. And there's a formality to it, and people react to that part of it. But what we often do not see is the political bargaining that goes on within, outside, parallel to that formal process. And that's an important part that I think should perhaps come out. Not in a total sense. Some of the concessions made, some of the compromises done will perhaps have to be confidential for some time. But it's important to remember that at the back of our minds, and perhaps even in front of our minds, that there is always an informal political bargaining that goes on. One of the most important parts of that bargaining is, in fact, whether the non-state armed actors who participate in a peace process have to submit to the legal system of the state. Nobody ever really asks that question when we negotiate with a non-state armed actor in the Philippines, whether it's the MNLF, the NDF, or now the MILF. What is the status of the non-state armed actor legally? Are they talking to the government because they are subject to the government's laws? These non-state armed actors either want to not be part of the state or want to overthrow the state. Why should we assume that they are submitting themselves to the legal system of the state? So how do you reconcile the idea that the state owns the legal system, has a monopoly of armed force, and yet talks to a group that does not want to be part of the state, wants to overthrow the state, and competes for the state in using armed force. In other words, law does not control this situation. And that's, I think, one of the first points I'd like to make. That when we talk about justice, it is not the same thing as law. And that's a very important point. It's usually lost in a discussion that's dominated by lawyers, some of them my classmates in law school, some of them my contemporaries, some of them younger than me, some of them even my students at the College of Law UP. So if you look at examples from outside the Philippines, you will understand perhaps what motivates armed groups in negotiating, in proceeding with negotiations, or perhaps in getting out of negotiations. Right now, for example, in Colombia, the FARC, a Marxist rebel group that's been fighting the state for over 50 years, is in negotiations with the Colombian state. They don't want the negotiations to take place in Colombia. They want it in Havana. They don't want to submit directly to the legal system of the state. They're negotiating for a separate legal process that will determine accountability. And I can go into that if there's time. In other words, it's important to understand the tension that goes on when you have a political process happening while the conflict is also still happening. The second point, and I think part of this was discussed this morning, history as a set of narratives. Some of these narratives are parallel narratives. Some of these narratives intersect. Some of these narratives simply just go on separately. And one of the fundamental concepts in the work we do in transitional justice is to think about justice as a form of acknowledgment. That justice must also be an acknowledgement of the narratives of the other, of the narratives of those who are not part of your own narrative. That there are multiple narratives going on, and that you must acknowledge that as well. In other countries, that acknowledgement of narratives, that form of justice as acknowledgement, has come through some of the mechanisms that are now talked about. A truth commission as a way of acknowledging injustices done. Or reparations as a way of addressing the impact of human rights violations, historic grievances, which is referred to, in fact, in the framework of the peace agreement. Because these mechanisms are ways of acknowledging what happened to others. A truth commission in itself will not resolve the conflict. Reparations in themselves will not completely heal the grievances and the wounds felt by those who were injured, by the families of those who were killed. But because they acknowledge what happened to people, what happened to victims of injustices, they at least convey a message to the others, to victims, to communities that have been excluded, that they can perhaps begin to trust the state. And so acknowledgement can help lead you to trust. It does not mean automatically you trust. It does not mean automatically you surrender and negotiate and give up and concede. But at least it builds the possibility of trust. Does it lead to reconciliation? We are often asked in our work whether transitional justice leads to reconciliation. If you look at the truth commissions that have been created in the world, as a matter of fact, until recently, until maybe about 2 years ago, there was only one truth commission that had reconciliation in its name. That's South Africa. Earlier truth commissions, in Chile, it was a truth commission. In Argentina, it was a truth commission. Truth commissions, even transitional justice in general, does not automatically or even easily lead to reconciliation. That's a different process altogether. It may happen, it may not happen, but to set it as a goal at the outset will create problems because it will make people think that if they don't reconcile, it failed. And I don't think that that should be the case. That reconciliation should be the objective of transitional justice in itself. A third point about justice. So justice is not law. Justice should be seen as acknowledgement. A third point. Justice is also about accountability. And this is often the most familiar part of justice for us. That someone should be held accountable. But, and this is not just in our country, in other countries as well. This idea of justice as accountability is often conflated with criminal justice. That individuals should be prosecuted and then punished and therefore held accountable. But I think justice as accountability is more than individual accountability, is more than criminal justice. In other cases, it may not even be about criminal justice. If I may mention Colombia again as an example. The idea that leaders of the FARC, the guerrilla group, as well as leaders of the state's armed forces should be prosecuted is one of the negotiating issues right now. It's one of the thorniest issues in that peace negotiation. And the problem there is, I think, because of the focus on individual accountability as justice, that everything else is held hostage because we cannot resolve the question of who should be prosecuted. Justice as accountability is more than individual accountability. It should also be about institutional accountability. What institutions fail? What institutions should you change? And in a way, this also leads to one other aspect of transitional justice, which is institutional reform. One of the things I talked about earlier over cigarettes was the experience that the Philippines has had integrating leaders of the Moro National Liberation Front into the armed forces. No one talks about that. People hardly know about that experience. But I think it's important to examine that, not because it's a success, not because it's a failure, but because it's an attempt at actually practically dealing with the consequences of a peace agreement, or at least the consequences of a political bargain. I was in the DND when part of the integration program of the MNLF was being implemented, and I saw some of the most practical problems that I think are partly rooted in lack of acknowledgement. The requirement, for instance, that an MNLF combatant be at least second year college to become an officer in the armed forces. That was one of the most impossible requirements to insist on. And it's important for government to learn these things as early as possible, to understand the technical issues that might have to be part of the consequences of peace. Finally, and in many ways, this might even be one of the most important notions of justice to remember, we shouldn't only talk about justice as an end, but we should also talk about access to justice. Do people have access to justice? And access to justice, again, should not be limited to our ideas of being able to sue or being able to defend yourself in court. That's obviously access to justice. We're obviously talking about one particular form of access to courts. But access to courts is not the only concept of access to justice. You can have the concept of access to rights. Are people able to exercise their rights? And a good example that I think is relevant to this discussion, I mentioned the reparations law. I'm also here to try to meet with the agency implementing the reparations law, and they're having trouble registering and recognizing victims from the Bangsa Moro who were victims of human rights violations during the Marcos dictatorship. The problems can range from the very simple and practical. No death certificates, no birth certificates, no proof that someone was injured or someone was killed, simply because where do you get that? And we face the problems elsewhere. I work, for instance, in Kenya. There's a part of Kenya that's very close to Somalia. People there have been massacred. People there have been excluded. Now there's a reparations program that might be implemented. The same thing. They don't even recognize Somalians who are born Somali Kenyans as Kenyan citizens. And so you have very practical problems of access. But you also have more substantive philosophical questions of access to justice. the question of Sharia, for instance, the question of identity and what it means. These are complex issues that right now might be too premature to talk about, but I think are important to remember at the back of our minds. I work in Tunisia, for instance, and there one question has arisen. Women during the Ben Ali dictatorship were forced to take off their veils by the dictatorship because he wanted to be French, the dictator, and he wanted to be secular. And in his insistence on secularism, he wanted to enforce a policy of banning veils in state institutions. And so it has now come up. Was there a violation of human rights? Was there a failure to recognize identity and what it means to women who are practitioners of Islam? So you have those various concepts. Let me end with another story, similar to Congresswoman City, but this also bothers me the way my entrance into Abu Bakar bothers me. I was still in the Department of Defense. I received a letter that was ignored by the armed forces, and the only reason I received it was I was copied. It was directed to the Chief of Staff of the Armed Forces. It came from a teacher in Basilan. I think she was a high school teacher in one of the remote towns. One of her students was asked to stay after class to clean the blackboard and to sweep the classroom. He forgot to do that. He had gone home and he decided, I should do that. So he borrowed his brother's motorcycle, went back to the classroom to clean it. On his way back, he was shot dead because supposedly they thought he was a member of the Abu Sayyaf. My concern was that it took his teacher several letters to the armed forces. Nobody bothered to even reply. And so I replied to the teacher. I said, we will send an investigation unit to go to that school and find out what happened and see what forms of accountability should be pursued. When I asked the Judge Advocate General's office to send a team, the response was, we can't. And I said, why not? And their answer was, it's too dangerous. And I thought it was the most ridiculous answer ever from the state's armed forces, who could not go investigate something because it was too dangerous. And so up to now, I have no idea what happened. I had already resigned by the time I had sent these letters out. And these are the stories we never hear about. This is a story I only learned because I was in a government office receiving a letter. And I think this is where we must begin to understand what injustice might be. The first injustice is injustice that is not even ever acknowledged. So let me end there.